Unconfirmed Acting Secretary Julie Su has now nearly tripled the old record for a stalled nominee.
The Republican economic agenda in the states appear to hinge on putting children to work.
You just say, well, okay, we found little Johnny at 2 in the morning in the factory.
The Biden administration has lost 85,000 children. Well, you're failing at it. I wouldn't give you a penny.
Okay, but the question I asked, can you answer that?
Working on the kill room floor, automobile, that's the word I'm looking for.
That doesn't make any sense.
Okay, you're giving me generalities and you're avoiding my specific question.
Congressman Good, thank you.
You don't have to say my name each time, by the way. That's a stall tactic.
Congressman Good,
You don't have to say my name each time.
Oh, sorry, Congressman Kiley, I'm concerned about.
I'm not Congressman Kiley, but
I'm sorry, Congress.
You don't have to say my name. It's okay.
We all are making laws for business owners, yet we don't listen to them.
We're listening to them.
Oh, my heavenly days. Never mind, because we're not going there. I mean, my goodness gracious.
The subcommittee is meeting today to hear testimony on the Department of Labor's Wage and Hour Division's policies and priorities. Ms. Looman, one glaring constitutional anomaly at your department, the Department of Labor, must first be addressed. On July 21st, 2023, unconfirmed Acting Secretary Su set a record for time spent in Senate purgatory. That was quite a while ago when she set that record, July 21st, 2023. She became the longest stalled nominee ever while her party controlled the Senate and White House. On January 4th of this year, I wrote a letter along with Chairwoman Fox making a common sense request to the president that Ms. Su not be renominated to a position for which she had already been rejected. Unfortunately, 4 days later, she was. Unconfirmed Acting Secretary Julie Su has now nearly tripled the old record for a stalled nominee. Her presence at the helm of labor refutes any notion that the president planned on running a transparent administration. I'll now turn to the introduction of our distinguished witness. Our witness today is the Honorable Jessica Looman, who is the administrator of the Wage and Hour Division at the U.S. Department of Labor, located in Washington, D.C. Ms. Looman was sworn in as administrator on November 29th, 2023, following a Senate confirmation vote of 51 to 46. Ms. Looman has led the WHD through the entirety of the Biden administration, where she previously held the position of acting administrator and principal deputy administrator.
Could you tell us why the proposed rule was pushed through so quickly and in such an unprecedented manner?
Thank you, Congressman Burleson, for your question. As you know, the Fair Labor Standards Act includes the protection of workers from overtime. It's been a cornerstone of the law since its enactment. And so enforcing the overtime protections under the Fair Labor Standards Act is absolutely a priority of the Wage and Hour Division. As a matter of fact, about 84% of the back wages that we collect for workers is associated with their failure to receive the overtime that they have earned on payday. We have issued a proposed rule to address a specific exemption from protections from the Fair Labor Standards Act, which is the exemption that applies to executive, administrative, or professional employees. When an employee is exempt under that particular rule, under that particular law, that means that they don't get the protections of minimum wage or overtime. Therefore, it's very important that we're very careful about who is considered exempt for purposes of that requirement. We have proposed a rule, and the proposed rule was issued and will continue to be developed in compliance with the Administrative Procedures Act. And we did provide a 60-day comment period in which we received over 33,000 comments from people who were interested in making sure that we developed the best rule that we possibly could.
Imagine if you'd kept that period open to a normal length of time, how many comments you would have received.
Thank you, Congressman Burleson. Again, this rule is following on a rule that was adopted in 2019. It's been about 5 years since we updated the overtime regulation. And similarly, that rule was adopted under the APA and had a 60-day comment period. You know,
the 2016 rule that occurred under the Obama administration, it faced serious legal challenges and it was ultimately blocked. I expect and hope that the same outcome will happen with this.
The Republican economic agenda in the states appear to hinge on putting children to work and making them work for longer hours. What are the risks to children's educational outcomes when they work more than 20 hours per week during the school year?
Thank you so much, Ranking Member Adams. Addressing child labor and illegal child labor and child labor exploitation is a priority of the administration. And as you know, one of the primary focuses always has been of the Fair Labor Standards Act is to protect our most vulnerable workers, and that includes children.
What do you do with the child? I mean, if we have a child who is a minor and working illegally, do we call their parents? Do we say, do you know your child was working at the L&M manufacturing plant at 2 in the morning? Do you contact the parents?
So again, Congressman Grotham, we're responsible for enforcing the wage and hour laws and the child labor laws. But what we do, because we know that children are particularly vulnerable, and we want to make sure, and it's a responsibility of everyone across the community to make sure that we're protecting kids. We work very closely with community-based organizations. We work very closely with other types of agencies that provide services to make sure that kids have access to those services.
Do you make an effort to find that person's parents, to find out whether they're even living with their parents?
So again,
you don't consider that your responsibility. You just say, well, okay, we found little Johnny at 2 in the morning in the factory. We'll call some other agency and we'll maybe send a nasty letter to the employer, and we just don't care if that 15-year-old even has a parent in the country. Is that your attitude?
So Congressman Grotham, I care very, very much, and I care very deeply about every child who's employed illegally in this country. And we, of course, work very closely with everyone who can provide services and meet the needs of those kids. But we also are holding employers accountable for employing children illegally in the first place.
Okay. There was an article in the New York Times. The Biden administration insisted it was a high number. So let's say there's somewhere between 35,000 and 85,000 unaccompanied minors in this country. By that I mean their parents aren't even here. And obviously some people they're living with somebody's making money off them. Does that concern you? I mean, I would think if I found somebody, maybe if they could barely speak English, working clearly illegally, even if they were, by all accounts, an American child, I would call their parents and say, what's going on? Why is Johnny at such and such a place at 2 in the morning? Now, particularly in light of the fact that, according to the New York Times, tens of thousands of these minors have been lost. We don't even know where they are. Don't you think the bureaucracy has some duty to find out who's taking care of these kids or if their parents are anywhere to be seen?
Thank you, Congressman. We recognize that many times there are children who are particularly vulnerable to child labor exploitation, and this could include, and recognize that this could include immigrant workers and immigrant children.
You make no effort to contact their parents. I guess that's the final question.
And Congressman, I just want to say that our responsibility is to both keep these kids safe and also to make sure that employers stop employing children illegally in this country.
Okay, well, if you aren't contacting their parents, I don't see how you're making an effort to keep them safe. But we'll switch to another topic.
The role in which your agency helps individuals maintain the dignity of work and maintain the opportunity to earn what is owed to them and achieve that tenet of a good job. I just want to kind of understand the process here and what your investigators go through.
Thank you so much, Congressman Stevens. Really appreciate the question. And again, really value the work that we're doing at the Wage and Hour Division. Every single investigator who wakes up every day to really help workers and help employers and ensure compliance with the law. The Wage and Hour Division, as you say, we are very much focused on making sure that jobs are good jobs and that workers get their hard-earned pay on payday. And so we do that. A lot of the work that we do is really about preventing wage and hour violations from happening in the first place.
You can see on this chart the massive spike in child trafficking during the Biden administration because Joe Biden is allowing cartels to traffic children across our border. Administrator Looman, do you think the open border policies of the Biden administration have caused the increase in child labor violations?
Thank you, Congresswoman Miller. Pleasure to be here with you today. So the Biden administration is very much focused on ensuring that children are not employed illegally in this country. And we've launched several different efforts.
The Biden administration has lost 85,000 children. And actually, I was recently at the border, and the Border Patrol suggested that it was over 100,000. They have lost 85,000 children during this disaster at the border. The spike is during your administration. You own this. It is because of the border policies. Has President Biden taken any responsibility for the uptick in child exploitation?
Thank you, Congressman Miller. Absolutely. We're doing several things across the administration, including we have an interagency task force to address and combat child labor exploitation. We're working very closely with the Department of Labor, the Department of Homeland Security, the Department of Health and Human Services to make sure that we are addressing, combating, and preventing child labor exploitation from occurring all across the government. We're also working with states and other partners across the country to address this really important issue.
Well, you're failing at it because you can't even find the children. 85,000 minor children are missing. It's a disaster. You are allowing cartels to traffic children into our country and doing nothing to stop them. And I wouldn't give you a penny.
Administrator Looman, my colleague across the aisle here, Ms. Stevens, said that Acting Secretary Julie Su needs to get confirmed. Do you agree with that?
Thank you, Chairman Kiley. I am honored and privileged to get to work with Acting Secretary Su. Under her leadership, we are doing really important work at the Wage and Hour Division in the U.S. Department of Labor.
Okay, but the question I asked, can you answer that?
Chairman Kiley, I certainly defer to the U.S. Senate as to the confirmation process. But again, it's an honor and a privilege to get to work with Acting Secretary Su.
But we have, bipartisan, statements here, maybe meant a somewhat different way from myself and Ms. Stevens, that Acting Secretary Su needs to get confirmed if she's going to stay on as the head of the Labor Department. Do you agree with that?
Chairman Kiley, and I very much admire and appreciate and get to the opportunity to get to work with Acting Secretary Su.
Right, but do you think she needs to get confirmed?
Chairman Kiley, I certainly defer to the U.S. Senate, but under the Biden administration, we are very much focused on protecting workers and making sure that the U.S. Department of Labor is functioning in a way that absolutely is helping employers be successful.
Do you think having an unconfirmed secretary has affected morale at the Department of Labor?
So, Chairman Kiley, again, the team that I get to work with and everyone that I get to work with at the U.S. Department of Labor is very much focused on protecting workers in this country and making sure we have an economy that works for everyone.
Thank you for that, but I asked a different question. I said, do you think that having an unconfirmed acting secretary who set all the records for how long she's been there without being confirmed, do you think that has affected morale at the Department of Labor?
Chairman Kiley, I think morale at the U.S. Department of Labor is exceptional.
You've had some successes recently. Can you give us an example of some of those successes?
Yes, absolutely. Thank you, Congresswoman. So again, just recently, we had a case out of Minnesota where we were finding that there were teens that were employed illegal to operate dangerous equipment at a foods manufacturing facility. We have some cases across California where we found that children were being responsible for the meat packing facilities and actually working on the kill room floor, killing poultry. And that was a $3.8 million recovery of civil money penalties as well as violations, as well as other FLSA violations. And then we've also found children working in automobile, that's the word I'm looking for, an automobile manufacturing where we find those children working in violation as well.
In November, a witness testified before the subcommittee that automatic updates to the Fair Labor Standards Act's exempt employee salary threshold would violate the notice and comment rulemaking requirements of the Administrative Procedure Act and potentially the Constitution. The proposed overtime rule includes these automatic updates. What will you do to address these concerns?
Thank you, Congresswoman Fox. As we've discussed, one of the most important and foundational issues of the Fair Labor Standards Act is overtime protections for ensuring that workers get time and 1/2 of their regular rate of pay after 40 hours in a work week.
And we know that.
Okay. And the exemption for some workers to not get those protections is something that we're focused on in making sure that when we're adopting an appropriate level of salary threshold for that exemption, when workers don't get that protection, That's what we're working on and
But
looking
I
at
want
an overtime rule.
want you to address my specific question. We know what the situation is. Don't waste our time on that. Specific question. What are you going to do because you're in violation of the Administrative Procedures Act and the Constitution?
Thank you, Congresswoman Fox. We absolutely will adopt and ensure that where the adoption of the overtime regulation is in accordance with the Administrative Procedures Act, and automatically updating this salary level does comply with the APA and the Fair Labor Standards Act.
We'll see. WHD's budget is more than 20% higher than it was in FY 2013, demonstrating this is not a resource problem for you. It is a management problem. What management changes will you commit to making to improve these outcomes?
Thank you, Congresswoman Fox. Again, as we discussed, we have about 721 investigators to protect 165 million workers at 11 million workplaces across the country. And so we're very much focused on ensuring that we are protecting the most vulnerable workers. And that requires that we are particularly strategic with the utilization of our resources. We talked a lot about child labor and child labor exploitation, and we are making sure that we are putting and focusing our resources in that area. But we also are continuing to
But you had
protect-
more money and you did less work. That doesn't make any sense. What is the problem?
Thank you, Congresswoman Fox. As you know, the agency has been primarily flat funded for the last decade, and that has resulted in, as expenses and costs go up, that we have fewer resources to actually provide for the enforcement work that needs to happen, which is why we have, the President has asked for increased funding for the Wage and Hour Division.
But I would assume that we have learned from the action by the judge on Obama's rule, so we won't be going that direction again, will we?
So, Congressman Wahlberg, again, we are very much focused on reviewing all of the comments that we received and finalizing a rule, an overtime rule that will continue to protect workers who should be protected by the Fair Labor Standards Act.
What happens when someone is misdesignated as a lower classified worker when actually they're doing higher quality work?
So thank you, Congressman Scott. Sometimes there's sort of two different types of misclassification. So we talk a lot about, and we've been talking a lot today about misclassification of employees as independent contractors, but you're absolutely right. Sometimes when we're looking at federally funded construction projects, because we establish prevailing wages for different types of workers under the law, sometimes a worker may be paid the wrong prevailing wage under Davis-Bacon because they're not classified appropriately for the type of work that they're performing. And we very much work with the contractors, the contracting agencies, as well as workers to make sure that they're getting the correct prevailing wage.
I'd like to talk with you about the newly announced independent contractor rule, Administrator Looman. By the way, how many pages is that rule?
Congressman Kiley, I am not sure.
I think it's like about 330. Does that sound about right?
Congressman Kiley, that's very possible.
Okay, so under this new independent contractor rule, would licensed real estate agents, would they be classified as employees or independent contractors?
So Congressman Kiley, as you know, the independent contractor rule lays out a multi-factor, six-factor test.
Sure, and my time's limited, so I'm asking you about a specific example. Just take your typical real estate agent, classic arrangement with a brokerage. Are they an employee or an independent contractor here?
So Congressman Kiley, the independent contractor rule helps provide guidance under the Fair Labor Standards Act, which requires that employees get minimum wage and overtime, and that
okay, you're giving me
independent contractors
generalities,
don't.
and you're avoiding my specific question. Under the rule that you just announced, 330 pages for the 2 million real estate agents in America, is there an answer in there as to whether they're employees or independent contractors?
So, Congressman Kiley, as has always been the case under the Fair Labor Standards Act, it is a fact-based analysis as it relates to that individual worker and how they're performing work for their employer.
Okay, I'm just talking about the classic arrangement of a real estate agent who's sponsored by a brokerage. Would that classic arrangement, take for example, everyone who's exempted by AB 5 in California, would those folks qualify as independent contractors or as employees under the rule that you just announced?
So, Congressman Kiley, again, the rule that we just announced is a reflection of longstanding guidance as well as judicial precedent of what it means to be an
Well, good. Then it
employee
should be
or
easy to
independent
answer. Can you
contractor.
tell me whether real estate agents are employees or independent contractors under your new rule?
So, Congressman Kiley, real estate agents who are in business for themselves would continue to be considered independent contractors under the new rule.
Okay, how about truckers, independent owner operators? Are they independent contractors or employees under the new rule?
So again, Congressman Kiley, the requirement is that workers who are in business for themselves are independent contractors under the Fair Labor Standards Act, and workers who are economically dependent on their employer are employees.
I see.
And
So
get
let me
the
give you an
protections of the
example.
law.
Let's say that I'm a writer and I publish for Vox and I publish for the San Francisco Chronicle and I publish for a variety of local papers. Am I an employee or an independent contractor under your rule?
So again, Congressman Kiley, it would depend on the facts of that individual
I just gave you the
relationship, and
facts.
it's a six-factor analysis. It has always been a six-factor analysis as it relates to the judicial precedent and the long-standing guidance of the Department
Okay, so
of Labor.
you're the person who came up with the rule. It's 330 pages, and you can't tell me here some basic examples of standard professions that millions of people have, how they qualify. How is anyone supposed to make heads or tails out of this?
So Congressman Kiley, again, thank you for the question, because what we did in the regulation as well as in the small business guide is that we provided examples of how each of the six factors could apply and indicate an independent contractor or an employee for purposes of helping
Okay, so
with the
could you
analysis
apply
under
those
the Fair Labor
examples
Standards
to the
Act.
hypothetical I just gave you? Is that an employee or an independent contractor for a writer like that?
So again, sorry, Congressman Kiley, it would depend on the analysis of the six factors to that individual worker and the work that they're performing.
I see, and who's doing that analysis?
Congressman Kiley, the guidance that we put out in the regulation is to help employers do that analysis. And then we also, as we've discussed earlier today, we're very much looking for misclassification in our cases when it may have deprived a worker of receiving minimum wages or
In fact,
overtime.
yes, you gave us some examples of the work that your agency has done to address misclassification and the recoveries you've gotten to address misclassification. To be clear, you're doing that under the rule of the prior administration. Is that correct?
So, Congressman Kiley, again, we are doing this under the longstanding guidance as well as the information and in compliance with
But no.
all
My question is,
regulations.
you are touting your success in going after unscrupulous employers who are misclassifying workers. You're doing that without this new rule that you just announced, correct?
Congressman Kiley, we are very much focused on addressing misclassification, and
Could
we
you
are
just answer
doing
my
that
question?
under the standards.
You've
that
been
we are
able to
currently-
get judgments and recoveries for misclassification without this new rule, correct?
So, Congressman Kiley, we continue to look at misclassification, and this rule is to continue
The answer
to
is
help.
yes. So the reason you're stating for having this rule apparently is not needed. The rule isn't needed because you're already able to pursue these cases. Are you aware of the opposition that the freelance community has to this rule in the form of a lawsuit and many comments to the rulemaking process?
Congressman Kiley, I am aware of that.
And so why do you think it is that they oppose this rule so much?
So, Congressman Kiley, again, I think that one of our responsibilities is to continue to do outreach and education to make sure that freelancers who are in business for themselves understand they are protected by this rule.
Yes, and so my time is expired, so I just want to leave you with that question and give you one more chance. Based on your conversations with all these folks who say that this is going to threaten our livelihood, they've submitted comments, they've filed a lawsuit. Why do you think they are opposed to this rule that you just announced? What's your best understanding of that?
So, Congressman Kiley, I very much look forward to the opportunity to continue to talk with freelancers and other small business owners to make sure that they understand that this rule protects them in their ability to be in business for themselves.
Ms. Looman, are you concerned about the national debt?
Congressman Good, thank
You don't have to say my name each time, by the way.
Oh,
That's
okay.
a stall tactic. But are you concerned about the national debt?
So, Congressman Good,
You don't have to say my name each time.
Oh, sorry.
Are you concerned about the national debt?
I appreciate the question. My responsibility at the Wage and Hour
You
Division
work in the
is to
federal
enforce the Fair
government.
Labor
You have a
Standards
budget.
Act.
Are you concerned about the national debt?
So, Congressman Kiley, I'm concerned about.
I'm not
making-
Congressman Kiley, but-
I'm sorry, Congress.
You don't have to
I
say
won't
my
say your
name. It's okay.
Sorry, I am very.
Do you know how much the national debt is?
I don't know off the top of my head what the national debt is, sir.
Okay, it's $34 trillion. I'm not surprised because you asked for a 31% budget increase. Could you imagine if every agency and department of the federal government asked for a 31% budget increase? According to the Congressional Budget Office, repealing Davis-Bacon would save taxpayers $24 billion over 10 years. If we were to repeal Davis-Bacon, which is what we should do, it would save taxpayers about $24 billion over 10 years. Can you tell the American people why we should pay $24 billion more than is necessary for construction projects, federal construction projects? Why should the taxpayer have to pay $24 billion more for federal construction projects?
So our responsibility at the Wage and Hour Division is to enforce the Davis-Bacon Act as enacted by Congress and the 71 Davis-Bacon related acts. And we make sure that workers get the worker protections under that law, including getting paid prevailing wages for the work that they're performing.
Ms. Looman, most Americans have never heard of Davis-Bacon. As you know, it's almost 100 years old, having been created in the 1930s as a conglomeration of the many Jim Crow-era laws. It was intended to inflate wages of government contractors and eliminate competition in favor of white union workers, in favor of labor. My bill, H.R. 720, would actually repeal this discriminatory and inflationary policy that is the Davis-Bacon Act. But back in August, your department issued a final rule that not only didn't eliminate Davis-Bacon, as we should, but it updated it. Why would the administration prop up a law with such a racist history?
So our focus in the administration is to really make sure that federal investments result in good jobs. And the Davis-Bacon is one part of ensuring that workers who are performing work on federally funded construction projects get paid locally prevailing wages.
Well, in addition to the history, the racist history of the law, it's actually discriminatory today in a different way, because it discriminates against the 89% of the construction workforce that have freely chosen. I know the administration doesn't like that when workers choose not to join a union, but 89% of construction workers have freely chosen not to be represented by a union. Do you have any concern at all that Davis-Bacon discriminates against those 89% of the workforce that are construction workers?
The regulations that we enforce and the Davis-Bacon Act that we enforce really sets a level playing field for construction contractors who are bidding on federal projects, and then also sets a level playing field to ensure that all workers are being paid not less than the prevailing wages in their local communities.
Yeah, but it discriminates again against those who are not construction or union represented construction workers.
How many business owners did you consult before making this law?
So, Congressman McClain, we absolutely, specifically, as you're talking about the independent contractor or employee classification under the Fair Labor Standards Act, just to make sure we're talking about the same thing. We held listening sessions specifically for business owners and for
10, 20, 100, 1,000, 1,500. Give me a gut feel.
I believe we held about 27, 30 listening sessions. I don't want to tell you wrong.
That's okay. No, I'm looking for directional answers. It's honestly not a gotcha question. Because what I think the American taxpayer is frustrated with, the American people are frustrated with, and the business owners is we all are making laws for business owners, yet we don't listen to them. We don't take their opinion into consideration. And we make laws and we don't have any idea of the unintended consequences of what those laws will do to the actual people who have to administer those laws. So about 30 listening sessions. And what did the actual business owners have to say?
So, Congressman McClain, again, and I participated personally in a lot of these, so I do want to answer this question very clearly, although we had lots of team members.
But let's get to the
these.
answer.
So we heard a lot of feedback from business owners that they specifically wanted to make sure they understood what the responsibilities were under the Fair Labor Standards Act.
Were they in favor of it or against it?
So as we were listening to them,
my heavenly days. Never mind, because we're not going there. Let's go on to another question that we can answer, right? And I'm going to share with the American people, if you get somebody who's in charge, especially in a government entity that can't answer a question, you should ask yourself, do we need to replace this person who can't answer a simple question? I mean, my goodness gracious, the disappointment that I have that you can't even answer a simple question is unbelievable. Yet you want to be in charge and you want to tell the very people who you have no clue about their business what they can and can't do. That to me is repulsive. But anyways, enough of my opinions. Why is the DOL focused on crushing the economic opportunities for a sector that employs 64 million people and, get this, nearly $1.3 trillion to the U.S. economy? Do you believe in entrepreneurship? Wonderful. Then how does this law incentivize entrepreneurship?
So this regulation specifically protects workers who are in business for themselves, and particularly
by making it more difficult for them to do business? How does that correlate?
So this regulation specifically identifies for purposes of
I would
implementing the Fair
disagree,
Labor
the
Standards Act.
truckers would disagree, the independent contractors would, the people that actually do the job, other than you that sit up there, have no answers to any questions, but want to pontificate on what you think is in the best interest of a sector that provides jobs for 64 million people and contributes $1.3 million to the economy. Critical. I'm sorry, Mr. Kiley, I am out of time and I yield back.
Sorry about that. Thank you, Mr. Chairman, and thank you, Administrator Looman, for your testimony today.
Without objection, there being no further business, the subcommittee stands adjourned.